Welcome to Organizing Life's Daily Demands. My name is Peter Gordon, and I'm the president of New York Financial Organizers. We're daily money managers. We help people pay their bills, file insurance claims, budget, and often act as a fiduciary, whether that could be a power of attorney, an executor, or a trustee. And the purpose of this podcast is to introduce the viewers and listeners to other professionals who help people organize life's daily demands. And this morning, I am thrilled to introduce to you Katya Sverdlov, who's the founding attorney at Katya Sverdlov Law Firm. And hi, Katya, how are you doing today?
Thank you so much for having me.
My pleasure. So Katya and I know each other through our business connections and the senior service industries. And I've asked her to come on here to talk about the importance of a power of attorney, healthcare proxy, and possibly about guardianship as well. And Katya, why don't you give us a bit of background about yourself?
So I started out after college in investment banking, doing mortgage-backed securities and CDOs. So as far away from estate planning as could possibly be.
What's a CDO?
Collateralized debt obligation. If you saw the movie The Big Short, they explained it in great detail.
Yeah, that's the best place to get an explanation of it.
Yes, I agree. Entertaining and yet extremely accurate. So that's what I did. I actually know quite a lot of people that were portrayed in that movie. And I spent 12 years on Wall Street doing investment banking and risk management. And after the financial crash, I wanted to do something that was a bit more meaningful and doing something where people cared about the outcome. So I went to law school and I became an estate planning attorney. And it seems like a perfect combination of my financial skills. I understand stocks and bonds. So I understand what people have, various assets. I understand real estate quite well, both from my previous background and as an investor owner myself. And I care. I have aging parents as well. And it doesn't matter how much assets people have, whether it's $100,000 or $100 million. In the end, it's people's savings, life savings. In the end, it's people's families. In the end, it's people's legacies. So I help people plan now to avoid the chaos later. And that's what I do. I help first I talk to people, of course, and I try to understand what is it that they want. And then we see if we can actually get it accomplished.
Yeah, right. And so there's something called advanced directives, and that's the power of attorney, healthcare proxy, living will. Why don't you talk a little bit about why people need those?
So it comes as a shock, especially to immigrants who came from other countries. But if one becomes incapacitated, no one is allowed to make financial decisions for you. Not your spouse, not your adult child, not your sister. The legal answer is nobody. And that means no one can access your bank account, no one can access your sell your real estate, no one can talk to Medicaid on your behalf, or to a lawyer, or to an accountant, to IRS. And so what happens if someone is incapacitated and does not have a power of attorney? They have to go to guardianship, which I'll talk about in a little bit longer, but it's a long and painful and very embarrassing process.
Painful is a very good word.
Yes. And so power of attorney is a document that you have to sign while you have capacity, which allows someone else, another adult, to make financial decisions on your behalf in case you become incapacitated. And it's interesting because people, like when I bring it up, and honestly, it's the most important document that I do. When I bring it up, people get offended and like, what do you mean? But I have my full capacity. I know, which is why I'm bringing it up now, because if you lose your capacity already, it's too late. And this is what happens. People start to lose capacity, and very unscrupulous neighbors, home care agents, estranged children or relatives come into people's lives and get someone to sign this and then basically abuse them financially. So to avoid that, one has to sign a power of attorney now while one still has capacity, because you never know. It's not just Alzheimer's, it's not just Parkinson's, it's not just dementia. The worst case that I saw was actually a 35-year-old man who was standing on a sidewalk, not even crossing a street, and a car slammed into him and he became incapacitated. And for 2 years, his wife and his sister fought over who should be the one making financial decisions. So it doesn't matter that you are healthy and young and doing great. More power to you. I hope you stay this way for many years to come. This is like an insurance policy that takes care of you in the event of incapacity.
Yeah, and it's interesting you say that he was a young man. I'm partners with my son, as many people know, and he's very proud that he has an estate plan and with a power of attorney, among other things. And it's constantly telling people that they need to do this. And it's kind of shocking about how many older adults don't get the value. And I really appreciate your really wonderful explanation of the benefit.
Right. Because what happens if you don't, right? So what happened to that man and what happens to a lot of other people? So let's say you never signed the power of attorney and now you are incapacitated. Someone has to be able to act on your behalf. Someone has to pay your mortgage if you have one, or your rent, or get a home care aid, and someone has to access your money. Again, like I said, the answer is no one is allowed to do that unless now they go to court. And it's the Supreme Court that focuses on guardianships. And guardianship.
In our case, the Supreme Court of the state of New York, which is
Correct.
the lowest court.
Correct. And guardianship is a process. It's a judicial process. It starts with, so first somebody has to bring that petition. Usually it's a family member, but it doesn't have to. It can be a landlord. It can be a not-for-profit, alleging why this person is incapacitated and why they need someone else to be appointed to make decisions on their behalf. Everything comes out, right? Are you able to feed yourself? Are you living in a squalor? Are you starving? Are you wasting your money on silly things? The court does take this quite seriously, and usually the alleged incapacitated person is appointed their own attorney to represent their interest. And the court appoints a court evaluator who is a neutral party who is going to be interviewing everyone and writing a report. So there is a petition, there is an investigation. There is usually some form of fight because one son says, I'm the best person to take care of dad. And the other son says, actually, you're the one who stole money from dad. Absolutely not. You have no right to do anything. I'm the best person to take care of that. And in those cases, and the incapacitated person himself, dad may say, both of these as scoundrels, I am perfectly fine. Thank you so much. I'm perfectly happy living in the squalor that I am, and this is what I choose. And I don't want either of my sons around.
How would the court handle something like that?
It depends on the judge.
Right.
It depends on the court evaluator. It depends on the advocacy of the attorney who is assigned on behalf of the incapacitated person. And unfortunately, I cannot give you 100% guarantee on, and I see these cases all the time from various perspectives. Sometimes I'm the attorney who brings this petition. Sometimes I'm the court evaluator, being the neutral party, and sometimes I represent the alleged incapacitated person. In certain cases, it's clear that the person really is incapacitated. And by incapacitated, it means that unable to handle affairs of their daily living and unable to appreciate the consequences of that inability, right? Like somebody can be fully physically incapacitated, but have mental capacity and then they organize their life. And sometimes they don't. So if there is a fight like that amongst the kids and there are issues with both, the judge will appoint a third party, which is that what the father really wanted? Someone completely neutral, somebody who is completely does not know the family, somebody who really doesn't care that much about this person and will do the absolutely bare minimum. You want to avoid this. You want to avoid guardianships as much as possible. Again, sometimes it's
Absolutely.
necessary, but if possible, avoid it by signing a power of attorney and a healthcare proxy while you still have capacity, naming the person that you want to take care of your affairs in the event of incapacity.
Right. And tell us about the healthcare proxy.
So, power of attorney allows somebody to act on everything that's money related: banks, real estate, lawyers, accountants. Healthcare proxy allows someone to make healthcare decisions on your behalf. Again, if you're incapacitated. So who speaks to doctors? Who gets information from doctors? Who can advocate on your behalf with doctors? And ultimately, who makes the decisions to pull the plug or not? Um, Again, it should be someone who you know and trust, if possible. Otherwise, again, the judge will appoint someone who has no idea about your decision. Like I was a guardian for a few people when there was either no one in the family at all, or the family was incapacitated in various levels to make these decisions.
And you didn't know, and you had no clue as to what that individual would have wanted?
No, I did not.
Wow.
And so I made the decisions based on what I could gather from about that person, and then based on what the court would allow me to do, and based on my own view of that person's condition. So ultimately, the guardian has a lot of power, and if possible, you want that person to be someone who you know and trust. But again, if there is no one, some people, by the way, petition the guardianship court themselves. Like um, I saw a couple of times when someone is incapacitated, starting to lose capacity, they can self-petition the court to appoint someone for them if there is no.
Wow. And they recognize that.
Mhm.
That's amazing.
Yeah, very,
Very
very rare, but it does happen.
And so, back to the healthcare proxy, I know from my experience, if you're going to be a healthcare proxy, it's very important to have conversations and understand what the needs and the desires of the individual are.
Yes,
And
and so I encourage strongly all my clients to actually put their wishes into the proxy, because you don't want the family having a fight over your bed. I don't know, I'm definitely aging myself, but if you remember Terry Schiavo case, which
yeah,
ultimately went to the Supreme Court, it was a woman in her 20s who had a heart attack and and went into a coma. She was married at that time, no kids, and she had parents. She had no healthcare proxy. After 2 years of her being in a coma, the husband wanted to disconnect her. And the parents fought tooth and nail and said, absolutely not. This is not what she would have wanted. And I mean, it was a horrible story because they connected her and disconnected her a few times, and it ultimately went into Supreme Court. I mean, again, which is why it's very important that you actually state your wishes. Maybe she would have wanted to live forever. Some people do,
Knows?
right? Somebody does that for religious reasons or because they want medicine to have a chance to catch up. And so people say that. Some people say, absolutely not. If there is a chance that I'm brain dead, just turn me off. Some people go even further than that. I had a client who said she did not want any form of life saving measures if there is a chance that she's going to be dependent on home care. She was a very proud woman. She wanted to be completely independent, and that is what she wanted, and that is what she got. So it's people have different wishes, very different wishes, and only you know what you want. So it's very important to actually state so that it can later be honored.
I have a client that I'm healthcare proxy for, and she really has no family. And the healthcare proxy stated that she didn't want any intervention, including antibiotics. And there came a time where the doctors, she has some internal bleeding, and they wanted to do an endoscopy. And so I try not to make decisions on my own. So I worked with the care manager, and then she did have a couple of friends, and we all talked together about what it was that we thought she would want. And it worked out well. And it was because she put that information into the healthcare proxy.
Right. So again, people fight over what did dad actually want. So very important to put that in the healthcare proxy. People do fight about who gets to make financial decisions quite a lot. Very important to put that in the power of attorney. And like I said, sometimes this power of attorney is given to unscrupulous people, right? When somebody, it's the hardest period of time when someone is starting to lose the capacity, but they're not quite there yet. They're not fully competent and they're not fully incompetent, but they can be easily influenced. And so that's when the power of attorney is given to wrong people. Once it's found out, again, I saw quite a few guardianship cases when the proposed guardian was seeking to invalidate a power of attorney that was given clearly under circumstances when the person did not understand what they were doing, like right after surgery, coming out of anesthesia, or 3 years
Right.
after having been diagnosed with Alzheimer's and needing 24-hour care. And then again, the court looks at the totality of circumstances. Was there any indication about what the person would have wanted beforehand? What is the person saying now? Does he have the capacity to understand what is happening? Who are the people who are petitioning? Are they nice, upstanding people, or have they declared bankruptcy? Have they had a felony? It's somebody who was trying to become a guardian, but turns out that she was a felon. There is a law in the state of New York that says a felon, convicted felon, cannot be a guardian. No matter how nice and upstanding you are right now, you cannot be a felon. You cannot be a guardian. Same thing with the bankruptcy. If you have declared bankruptcy in the past, you cannot be a guardian for somebody. Doesn't matter if you are now doing well, you cannot be a guardian. So the court looks at everything. But again, it's always usually such an embarrassing process for the incapacitated person because everything comes out. How have you been spending money? What is the condition of your house? What is your healthcare condition right now? What kind of doctors are you seeing? Like everything that's usually kept within the family comes out. And sometimes it's an absolutely necessary step because there are vultures circling around and someone does have to be appointed. And sometimes it could have been avoided by having a proper power of attorney.
Yeah. Yeah. Well, that's great. That was a wonderful explanation of of all things. And I'd like to return to the topic of guardianship going forward in another interview. So I want to thank you so much, Katya. We'll have your information in the notes on both the video and the audio, but tell us the best way to for people to get in touch with you?
Call the office. Call my office or email us, and we reach out.
Yeah, excellent. So thank you so much. That was wonderful. And so long to all the listeners and viewers, and I'll see you at the next podcast.
Thank you so much for inviting me.
You're welcome, Katya. Wow.